Behind these doors to the Senate chamber of our State House in South Carolina, on the last day of the 2010 legislative session, comprehensive tort legislation died. $210 billion. That's the estimated total cost of litigation for Fortune 500 companies. Last year alone, small businesses in the United States paid over $105 billion for tort liability. These costs are exorbitant, unreasonable, and create an unpredictable business environment in our state during a time when we cannot afford to lose jobs or new investment. As an experienced executive and lawyer, I can tell you that the fear of litigation is very real and paralyzing for business owners large and small. Almost all businesses believe that lawsuits are a major issue negatively affecting their bottom line. For instance, 6 out of 10 small business owners feel that they would be able to increase their revenue if there was assurance that they would be protected from frivolous and unfair lawsuits. During uncertain economic times, it becomes even more critical for our state to ensure a fair and predictable legal climate to grow existing businesses and to attract new businesses. Now, last year, our state received a major business win by landing Boeing, and while there were many factors influencing the company's decision of locating here, state leaders such as Secretary of Commerce Joe Taylor and Speaker of the House Bobby Harrell credit fundamental issues like tort laws and workers' compensation as playing a key role in the location decision. Now, let's discuss what the legal reform issues that our coalition will be advocating during the 2011 legislative session. Punitive damages reform is a top priority. North Carolina and Virginia have limits on punitive damages that provide predictability that the business community needs to thrive in our global economy. North Carolina limits punitive damages to $250,000 or 3 times actual damages. Virginia limits punitive damages to $350,000. Punitive damages are meant to punish a wrongdoer for egregious conduct and to deter future similar actions. Remember, in addition to punitive damages, the plaintiff is also entitled to full compensation for their injuries, including pain and suffering. Currently, South Carolina is the only state in the Southeast that does not limit the amount of punitive damage awards. We are seeking a reasonable limit of $350,000 or 3 times actual damages, whichever is greater. We want our legal system to be fair and predictable like our neighboring states. Also, our proposal does not limit punitive damages if the defendant's conduct was intentional, if he was under the influence of alcohol or drugs, or if the injury occurred while the defendant was committing a felony. We're only trying to protect our good businesses, not bad actors or felons. Did you know that if you're a defendant in a wreck case in South Carolina, you cannot tell the jury that a plaintiff was not wearing a seatbelt? Even if the plaintiff's damages were caused by his failure to obey the law and wear one. We need to restore common sense in the courtroom. Our coalition is proposing that the prohibition on admissibility of failure to use a seatbelt be repealed. This would subject seatbelt usage to the normal rules of evidence during a trial. The right of appeal must be protected. Today, there is no limit on the amount of an appeal bond that a South Carolina judge can require a defendant to post before they can file an appeal from an unjust jury verdict. This could force an individual or a company into bankruptcy. Our proposal limits the amount of an appeal bond that a court can order to the amount of the judgment or to $25 million for a larger business or $1 million for a small business or individual, whichever is less. Right now in South Carolina, we have some plaintiffs' attorneys citing unrelated building code violations to circumvent the time limits on when lawsuits can be filed in construction cases. We're advocating a common sense approach by saying a mere allegation of fraud, gross negligence, or recklessness does not allow you to get around the time limit, but that such violations may be introduced as evidence at trial. The South Carolina Civil Justice Coalition supports accountability and openness in our state government, especially when it comes to the state's hiring of private lawyers to sue businesses. In addition, we believe contingency fee arrangements need to be fair and to protect the state. We propose that the General Assembly pass legislation recommended by Attorney General Henry McMaster to provide for the regulation of contingency fees to be paid by the state, and that these contingency fee contracts be made open to public inspection. In closing, if we restore common sense to the courtroom, it will lower litigation costs for South Carolina businesses, allowing our businesses to concentrate on growing and creating new and better jobs. Thank you.